Hello, everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. In this video, we're going to talk about U.S. immigrants may soon need to share social media details with USCIS. Applying for a green card? You may soon have to provide social media information on your immigration application. In a notice published in the Federal Register on March 5, 2025, the U.S. Department of Homeland Security said it will require millions of immigrants seeking benefits ranging from green cards to citizenship to provide social media details on their applications. DHS plans to collect social media identifiers, handles, on 9 immigration forms under Executive Order 14161, protecting the United States from foreign terrorists and other national security and public safety threats. Signed by President Trump on January 20th, 2025. The order directs federal agencies to strengthen immigration screening and vetting procedures. It reinstates some policies from the previous Trump administration and requires a review of visa and immigration policies for security risks. According to the notice, U.S. Citizenship and Immigration Services will collect social media handles but not passwords to verify applicants' identities and assess security or public safety risks. N-400 Application for Naturalization. I-131 Application for Travel Document. I-192 Application for Advance Permission to Enter as a Non-Immigrant. I-485 Application for Adjustment of Status. I-589 Application for Asylum and Withholding of Removal. I-590 Registration for Classification as a Refugee. I-730 Refugee/Asylum Relative Petition. I-751 Petition to remove conditions on residence. I-829 Petition by an investor to remove conditions on permanent resident status. USCIS estimates this proposal would affect over 3.5 million applicants annually. The public has 60 days to submit comments on the proposal via the federal e-rulemaking portal. DHS will review feedback before deciding whether to implement, modify, or withdraw the rule. Social media monitoring in immigration applications. USCIS officers have monitored social media for years to detect fraud in visa, green card, and citizenship applications. Changes over the years. 2016, USCIS created a social media division within its Fraud Detection and National Security Directorate. 2017, the Trump administration introduced extreme vetting, expanding social media checks for visa applicants. DHS issued a notice confirming the collection and storage of social media information. 2019, the Department of State made social media disclosure mandatory for visa applicants. 2021, the scope expanded to include international platforms from China and Russia. 2025, Executive Order 14161 formally expands social media data collection to 9 immigration forms. Law enforcement has always used social media for investigations, but the scale of systematic collection is now much broader. Is the U.S. government overreach? The policy has reignited debates about surveillance and data privacy. Posts may be interpreted for intent or affiliations, yet subjective analysis risks misinterpretation, infringing on First Amendment rights of the U.S. Constitution. Data retention, likely perpetual in A files per DHS precedent, lacks clear statutory limits, challenging Fourth Amendment protections, and potentially enabling perpetual surveillance. Sanuja Kashyap, partner at King Stubb and Gasiva. The First Amendment protects freedom of speech, expression, and association. Kashyap pointed out that analyzing social media posts for intent or affiliations could lead to misinterpretation, potentially violating free speech rights. The Fourth Amendment protects against unreasonable searches and seizures. Storing personal data indefinitely in A files, immigration files maintained by DHS, could raise concerns about privacy and government overreach. Guidelines for flagging possibly tied to national security or fraud remain undefined, inviting arbitrary enforcement and potential discrimination. Without transparent standards or appeal mechanisms, due process is undermined, disproportionately impacting vulnerable immigrants. Given its potential to chill free speech and disproportionately impact certain groups, this policy demands strict judicial oversight, transparency, and due process safeguards Kashyap said, DHS has not clarified how it will choose or store the collected information. The agency has stated it will include search results, social media handles, aliases, and associated information in an immigrant's file. How will this impact Indian applicants? The policy, if implemented, will apply to all immigrants, including those from India. This policy, focused on national security and identity verification, may lead to scrutiny of their online activities. Ketan Mukherjee, senior partner at Bergen Law. USCIS officers monitor social media for fraud detection, discrepancies between social media activity and application details, security threats, links to terrorist organizations, extremist views, or threats to public safety, relationship verification, authenticity of family-based immigration applications, employment verification, checking LinkedIn and other platforms for work history and qualifications, identity verification, ensuring applicants' social media matches their official documents, character assessment, posts that may indicate unlawful activities or poor moral character, immigration violations, evidence of unauthorized employment or visa breaches, consistency, ensuring that online information aligns with immigration applications. If officers find potentially relevant content, applicants may be questioned during interviews, asked to provide additional evidence, or face denial of benefits. Discrepancies could result in a notice of intent to deny or other legal actions. To protect themselves legally, immigrants should be cautious about their social media presence, ensuring privacy settings are restrictive, and avoiding any posts that could be misinterpreted as threatening or fraudulent. Additionally, Indian immigrants can protect themselves by maintaining accurate and consistent documentation, ensuring that their social media profiles align with the information provided in their immigration applications to ensure compliance with all applicable laws and regulations. Mukherjee said, while the policy is intended to enhance national security, it has sparked widespread concerns about privacy violations, data misuse, and potential discrimination. Immigrants are urged to ensure their social media profiles align with their application details to avoid delays or denials. The final decision on implementing this rule would depend on public feedback within the 60-day comment period.
Hello everyone, welcome back to our channel US Immigration News. We hope you are doing great. In this video, we are going to talk about US immigrants may soon need to share social media details with USCIS. The US Department of Homeland Security has proposed a new rule requiring immigrants applying for a green card, citizenship, and other benefits to disclose their social media handles under Institute Order 14161 signed by President Trump on January 20, 2025. The policy aims to enhance security screening by verifying applicants' identities and assessing potential threats. DHS will collect social media information across the 9 immigration forms, including naturalization, asylum, and adjustment of status application, affecting over 3.5 million applicants annually. The order reinstates Trump's previous policies on extreme weighting and expense social media checks for immigrants. USCIS officers will not request passwords but will monitor applicants' social media presence for potential fraud, identity inconsistencies, or security use. The public has 60 days to comment on the proposal before DHS finalizes its decision. Critics have raised concern about privacy violation and potential misuse of social media content. Legal experts warn that analyzing posts for intent of affiliations may lead to misinterpretation, risking First Amendment violation. Additionally, storing social media information identifiably in a file's immigration files may breach both amendment protections against unreasonable searches and seizures. Without clear guidelines on data usage, the policy could enable arbitrary enforcement and disproportionality target vulnerable communities. Policy could significantly impact Indian applicants seeking U.S. immigration benefits. USCIS may scrutinize their social media for identity verification, employment history, and relationship authenticity. Any inconsistencies or controversial content could trigger requests for evidence, interview questioning, or application denial. Immigration lawyers advise applicants to maintain consistent information across their application and social media profiles to avoid potential complications. The video has sparked debates about government overreach, data privacy, and free speech. Critics fear that subjective interpretation of social media posts could lead to wrongful denials or delays. Legal experts stress the need for a clear guidelines, appeal mechanism, and judicial oversight to protect immigrant rights. The outcome of the 60-day comment period will determine whether the DHS moves forward with implementing this controversial policy, raising broader concern about privacy and surveillance in the US immigration process.